Yes, Mr. Wilson.
My Lady, my Lords, just two short matters of housekeeping which I hope assist the court. Firstly, my Lord Justice Jackson asked questions as to the framework of the Act. Given time, I don't propose to go there. However, what I would say is that Protect's interventions include the very helpful Annex A.
Thank you.
You find in various places across the bundles. Supplemental bundle in Rice, page 73. We agree with it. Secondly, the claimants have discussed the question my Lord asked as to whether there's any legally relevant points of factual distinction. The claimants do not say that there are.
Thank you.
Now, we were on 47B1B and what to make of paragraph 46 of Mr. Justice Bourne's decision. We say it's of note that the proposed construction of 47B1B is conspicuously absent in at least the written argument of the employer. Just as tellingly, we note that those acting for the employer and Barton Tools propose no less than 3 alternative interpretations of a provision that's supposed to guide responsible whistleblower and employer and co-worker alike. Those acting for Mr. Rice say this in respect of the Court of Appeals judgment and ordinary principles of statutory construction. Ossipov is right as a matter of statutory construction and logic. Follow the structure of section 47B to its simplest conclusion. That is to say that where there was no exclusion of dismissal detriment vis-a-vis the co-worker, having decided that whistleblowing detriment was so unique and serious as to warrant the imposition of individual liability, it would seem absurd and counterintuitive that Parliament would want to exclude that accountability for the most consequential detriment which may take place in employment, namely dismissal. And having got that far, as everybody understood, the entire premise of the appeal in Ossipov was that the necessary consequence of that was section 47B1B bites. There, in our submission, is what is dispositive of this appeal. There is no basis on the face of the wording or as a matter of legislative construction to provide any gloss on section 47B1B, which deprives rather than enhances protection. We say whether as a matter of ratio or dicta, the essential conclusions in paragraph 91 have much to commend them. And the contrary reading offends the certain core principles of statutory construction and gives rise to incoherence and absurdity. Some of those consequences being identified by Lord Justice Underhill at paragraph 68 of the court's decision. You have a full citation of Benyon in the bundle. We would rely upon 4 maxims of statutory construction. One that regard should be had to the consequences of a construction, page 1489 of the Supplemental Authorities bundle. 2, it's necessary to give effect to a legislative purpose, para 12.2 or section 12.2 of Benyon, page 1497. 3, the presumption against evasion, page 1521. And 4, the presumption against absurdity, 1526. In brief, I'd say that to uphold the EAT decision would be to license 4 absurdities at least and give rise to 2 practical incoherences. And I'll spell them out shortly. First, on the absurdities. 1, the worker would have the benefit of a looser causal threshold or a more beneficial burden of proof provisions to bring a claim for the end of their engagement than employees. 2, the individual wrongdoer, and in turn the employer, is not liable where they in fact dismiss, but they would be liable for post-termination losses were the claimant to resign following a lesser sanction on Roberts and Wilson but-for causation principles. So if the claimant resigns in response to a first written warning, all post-termination losses are recoverable, but if they dismiss on the reading of the urged by the employers and Mr. Justice Bourne, they wouldn't be, save in the unidentified certain circumstances. 3, and similarly, the individual who manipulates a dismissal via tainted information is primarily liable and their employer vicariously liable, but not the wrongdoer who in fact dismisses, contrary to what may be suggested by others. They may dismiss in the face of compelling disciplinary investigation, say, pointing the other way. In short, the provisions designed to impose liability on co-workers remove that liability for the most egregious and most consequential detriment that they could inflict. And 4, the whistleblower is less protected than the individual raising a protected act under Section 27 of the Equality Act, notwithstanding the conclusions of Mrs. Justice Simler and Lord Justice Underhill, that in this respect it would be surprising if Parliament intended a different outcome under the 2010 Act compared to the post-ERRA changes. See paragraph 157 of Mrs. Justice Simler's decision and 69 of this Court's decision. That's the absurdities, now the incoherences. And there are 2. 1, I think we can all agree, I would hope, that one of the benefits of Osipov in this Court is that it did away with arid distinctions between what amounts to a dismissal and what does not. At first instance, in Osipov, it was suggested that communicating a dismissal or instructing a dismissal would be a discrete matter. And this Court, understandably, decided that to replicate what's known as the Johnson exclusion zone when it comes to the recovery of losses on the face of a statute would be to repeat what Lord Justice Underhill described in paragraph 69 as a necessary evil. Second, on the approach of the EAT in the Wicked Vision Appeal, the extent of liability for the wrongdoer is subject to steps which may fluctuate during the course of litigation and would in any event be an exercise of pure speculation. And this is the fork in the road, respectfully, that the EAT judgment faces. If it were to deny any guise of dismissal detriment, that would plainly fly in the face of the oratio and Osipov, however narrowly or broadly construed. And what we're left with, therefore, is this language of in certain circumstances the claim may be crucial. The law must be clear, certain and knowable, both to those seeking protection and those who face the prospect of liability. The PIDA provisions are a living instrument. Blowing the whistle is a precarious career move, and an individual taking that brave step must have clarity on their rights and remedies before doing so. And it's perhaps of note that the evolving circumstances such as solvency, which the EAT below observed, clearly aren't knowable, as the present case illustrates. The claimant was dismissed on the 18th of February 2021. The amendment was granted on the 8th of July 2022. March 24, we have the EAT's decision. Since that decision, the corporate employer has entered insolvency, and in April this year, Mr. Strang sadly passed away. Now, when being dismissed and when presenting the claim, could those matters be known? So we say as a matter of principle, to conflate the question of liability with enforcement is wrong, and it is practically incoherent as well. Take the converse scenario. The EAT suggests that solvency may be an important factor to consider as to whether a claim might be viable under 103A. Let's say at the time of dismissal and presenting the claim, the employer doesn't look good for the money. Doesn't look like a 103A claim is practically viable. And so in those circumstances, on the approach suggested by Mr. Justice Bourne, a claim against the individual under 47B would be operative. Let's say that same employer, by the time of the liability hearing, has a sudden change in its fortunes, wins a contract, suddenly becomes more viable as a respondent. Does the protection that previously existed under section 47B1A disappear by reason of those change of circumstances, when the underlying acts are one and the same? We say that the law in this arena is perhaps a little clumsy, to use the wording of Lord Justice Underhill. But if we go to the same paragraph in which that's addressed, paragraph 78, page 175 of the Court Authorities Manual, that paragraph is worthy of emphasis, along with the essential conclusions. That the Court accepted this approach to the meaning of section 47B2 does not produce a particularly elegant result. It is clumsy that an employee dismissed on whistleblower grounds should be able to pursue distinct causes of action with significant differences as regards the conditions of liability and perhaps compensation against his or her employer. It may well be that Parliament didn't really think through the technical challenges of inserting into the framework of the 1996 Act a scheme of individual liability borrowed from the discrimination legislation. But the resulting awkwardnesses are insufficient to justify a construction that would produce a much more serious anomalies and seems to me contrary to the overall policy of these provisions. Whether ratio, whether dicta, that is respectfully right. And to reintroduce the discrepancies, anomalies, and backward steps as a matter of principle in respect of a legislation that should be construed purposefully would be a step contrary to the indications that Parliament would submit and contrary to how these provisions should operate in the real world. My Lords, those are my submissions, unless I can assist further.
Thank you very much indeed, Mr. Milson. Yes, Ms. Matraghi.
Good afternoon. Your Lordships, Your Ladyship, I appear with Mr. Cohen-Zard and Ms. Vandenberg on behalf of the respondent Wicked Vision. I should say at the outset that none of us appeared in the EAT or the ET below, and in respect of Mr. Cohen-Zard, he's a late entrant to the case, and in respect of Ms. Vandenberg and myself, we are very late entrants to this case, and we all appear pro bono. As my Lordship, Lord Justice Coulson said, the nub of this case is about whether is about the unamended exclusion clause in section 47B2. That's the reason why we are all here, and the pure question of law that this court will need to determine is how section 47B2 of the Employment Rights Act is effective and bites on section 47B1B. That is the key to determining this appeal. I'm mindful of the invitation that was made at the start of this hearing this morning, that it would be useful to provide a high-level account of the structure of the legislation before descending into the detail at section 47B2, and I would like to take up that invitation. But just to summarise our position in respect of grounds 1 and 2, to start with, in respect of ground 1, the respondent says that the ratio of the case of Timmis and Sage against Osipov is far narrower than the appellant claimant asserts, and that as the EAT in this case has articulated, the real ratio in that case is that an employee is permitted to bring a freestanding claim of dismissal as a detriment under Part 5 of the Employment Rights Act, specifically under section 47B1A against a co-worker, and that properly understood, the ratio of Timmis and Sage did not determine whether section 47B2 precludes an employee from making a separate claim for dismissal as a detriment against their employer based on vicarious liability under section 47B1B. That was not a live issue in the appeal before the Court of Appeal. The employer IPL was not represented. It was not a party to proceedings by the time the matter came on in the Court of Appeal. The position of the employer was therefore not an issue in the case, and Mr. Justice Bourne, when interpreting Osipov in Wicked Vision, was right to conclude that it formed no part of the ratio. as he did at paragraph 42 at page 213 of his judgment. Moreover, the observations made by Lord Justice Underhill on the position of the employer on section 47B1B may well have been contemplated by him or assumed by him, but they were not a necessary step in the conclusions required to answer the essential issue in the case regarding whether an employee claimant was precluded from bringing a claim against the co-worker. And accordingly, the respondent says that the authorities on which the appellant claimant relies do not assist him. That's the summary of our position on ground 1. As for the summary on ground 2, this ground concerns the proper construction of section 47B2 in the context of this case, i.e. a claim brought against the appellant claimant, Mr. Rice, where he has not sought to bring a freestanding claim against Mr. Strang, the owner and notional co-worker, but where the original claim was one brought as a section 103 automatic unfair dismissal claim against his employer, and the amendment sought and permitted by the Employment Tribunal was to bring a dismissal as a detriment claim against his employer under the vicarious liability provisions under subsection 1B. That was overturned by the EAT below, as you've heard, and to cut to the nub of our response on this, we say that so far as dismissal is concerned, the way in which the legislation in Part 5 and Part 10 are to be understood is that for each prescribed ground, so here we say dismissal on the basis of protected disclosures or detriment on the basis of protected disclosures, but there are others which we will come to, such as health and safety cases, working time cases, being an employee representative and so on. We say that for each prescribed ground and for each of the types of claimant, i.e. workers on the one hand and employees on the other, the intention of the legislation is to provide one route to claim in respect of dismissal against their employer. And that as a result, for workers who are not employees, who I will call non-employee workers, that means that they must bring their claims in detriment under Part 5, and by contrast, employees must bring their claims under Part 10, here section 103A. And that is common across all prescribed grounds, where there is a detriment under Part 5 and there is the corresponding right to claim unfair dismissal under Part 10. And that is essential for us understanding and interpreting the exclusion provision under section 47B and the equivalent exclusion provisions that exist for other prescribed grounds, such as section 44.4 of the ERA, which is now in identical terms to section 47B2, which covers health and safety grounds. So this has the result that section 47B2 bites on any claim brought by claimants against their employers for detriment as a dismissal, either via section 47B1 or claims brought via 47B1A, where...
Just go back to the beginning of that sentence and start again, would you?
Yes. We say that as a result of that legislative framework, it has the result that 47B2 bites on any claims brought by claimants against their employers for dismissal as a detriment, whether that is brought as a claim under section 47B1 or whether it is brought as a claim under section 47B1A, that's the new provision that fixes individuals with liability, where the claimant then goes on to rely on the vicarious liability of the employer under section 47B1B. And we say that in both cases, 47B2 bites and it is consistent with the judgment of the EAT and prevents liability from arising. In effect, what the appellants are inviting this court to do, set out as errors of law, but really is to rely on what they consider to be anomalous consequences, which they say cannot have been Parliament's intention. But we say that the appellants, and to the extent that this is adopted by Protect, the intervener, they have insufficiently appreciated how section 47B and section 103A fit together in the broader legislative scheme set out in the ERA, and how it provides a coherent framework established for the prescribed grounds, which has been replicated at each and every juncture by Parliament to prohibit employees from bringing claims under the dismissal claims under the detriment provisions. And so I move then to address you on the architecture of Part 5 and Part 10 of the Employment Rights Act. Given what has already been covered, I will move at something of a greater speed than I otherwise would have done. But once I've set out the relevant architecture as point 1, I will then deal with some of the core elements in the judgments of Timmis and Sage and in the EAT and Wicked Vision, as well as one or two other authorities. Next, I will outline the tests from the authorities on grounds 1 regarding ratio and make submissions on grounds 1. And then lastly, I will outline the test of statutory construction and make submissions on ground 2. So in relation to the architecture of Part 10 and Part 5, stepping back outside the confines of this case and of the complexities of whistleblowing rights, the Employment Rights Act distinguishes on the one hand between rights which challenge the lawfulness of dismissal, which are set out in Part 10, and detriments for which a worker can challenge under Part 5. An explanation of this background is set out at paragraph 7 of the case of Wicked Vision, which is in the Core Authorities bundle at page 207, but I need not take you there now. We say that it's very important to understand the architecture of these mutually exclusive provisions as they relate to dismissal rights, because they provide all potential claimants with one route to challenge dismissal. That applies before 2013 and it applies after 2013. So if we start with the position before 2013 and Part 10, as Lord Justice Underhill noted in the Timmis and Sage case at paragraph 7, which is at page 156 of the Authorities bundle, Part 10 rights are unfair dismissal rights, and they are rights which go back to the Industrial Relations Act 1971. They are rights that exist for over 50 years, and he could have added, but didn't, are the bedrock of statutory employment rights on dismissal. Those unfair dismissal rights are held by employees alone, and the classic right to unfair dismissal is based on whether the reason or principal reason for the dismissal by the employer was a potentially fair reason, as set out in sections 98(1) and 2, such as redundancy or conduct, and if that is established, dismissal is assessed against a test of fairness, and as my ladyship has already said today, is subject to a qualifying period that at present is 2 years of service. However, for all other rights of unfair dismissal, of which section 103A is one in Part 10, those are not subject to a test of fairness, simply a test of whether the reason or the principal reason for the dismissal was the prescribed ground. If so, it is automatically unfair. So to take a non-whistleblowing example concerning the working time regulations, under section 101A of the Employment Rights Act, and in ordinary circumstances I would take you to it, but as I understand that you don't have the final additions to the authorities bundle, I can't take you to that now, but I understand a new copy is being provided to the court as we speak. Oh, we have some copies. Thank you. Is it? Thank you. In which case, may I hand up?
Oh, good, another bundle of authorities. For the meaning of one provision in one statute, I think we're slightly overdoing it, aren't we?
May I say what we've handed up amounts to about 20 pages in total, but
No,
Thank you very much.
We're grateful for
thank you.
the preparation that's gone into.
Thank you. So 1676, I do hope at least that the pages are, the pagination works at the bottom of the page.
Thank you.
that will tell you that in a working time case, same essential phrasing, an employee who's dismissed shall be regarded for the purposes of this part as unfairly dismissed if the reason, or if more than one, the principal reason for the dismissal is that the employee, and then it says, essentially took various steps in relation to not refusing to comply with a requirement which the employee imposed, or refused to forego a right under the regulations, and so on. So it is the same essential test that is used in section 103A, and I could have picked any of the other claims in respect of prescribed grounds. All those, that is the position in relation to Part 10. And all of these rights to unfair dismissal, as we've said, are dependent on the claimant being an employee. And that's true. So that is the position in relation to Part 10. By contrast, in relation to Part 5, the right to complain of unlawful detriment is set out in Part 5, and as noted by Lord Justice Underhill, these rights do not extend as far back as the unfair dismissal provisions and were created at various stages in the 1990s. And he sets that out at paragraph 14 of the Osipov decision at page 157. Now, in some cases, the right to bring such a claim is conferred on employees only, and in some cases it is conferred on workers. And just to take a step back, employees are those who work under a contract of employment. Workers include those who work under a contract of employment, but they also include a greater category of workers. We don't have section 230 of the Employment Rights Act in the bundle, but we do at page 1394 have a citation of that section. So the first category of worker are those who will work under a contract of employment, i.e. employees. But the second category are those who work under any other contract, whether express or implied, whether oral or in writing, who undertake to perform personally any work or services, whose status is not, by virtue of the contract, that of a client or customer of any professional business undertaking. So that's the difference in breadth, albeit we'll come on in a moment to the special case as it concerns whistleblowing. So in some cases, when in Part 5...
There's also an... Sorry to interrupt you. You might be coming to this, but there's also an extended meaning of work for the purpose of Part 4A and 43K. But maybe that's
Indeed,
we don't need to cover.
That is important, and I'm coming to it, my ladyship. Thank you. So it's important to note that in some cases, the right to bring a claim under Part 5 as a detriment is conferred on employees only. In some cases, it is conferred on workers, which, as I've said, would include employees. And that pattern of the split between detriment in Part 5 and dismissal in Part 10 is true of all the prescribed grounds set out in Part 5. So to give a first example, employee representatives' detriment. To take an example unrelated to this case, Section 47 of the Employment Rights Act, not to be confused with our provision, which is Section 47B, concerns, this is about architecture, so under the heading of employee representatives, this is page 73 of the authorities bundle, the supplementary authorities bundle, sets out that an employee has a right not to be subject to any detriment by any act or failure to act done on the ground that being an employee rep in respect of redundancies under various statutory provisions, the employee performed or proposed to perform any of those functions. And so there is a parallel right to unfair dismissal there under Section 103 of the Employment Rights Act, which you can see at pages 1679 of that recently handed up bundle a moment ago. And so what Lord Justice Underhill was noting in respect of Part 5 and Part 10 is that those two parts provide substantially self-contained, albeit largely parallel regimes governing the rights that they protect. Now, because unless it is specifically disapplied, dismissal itself could be treated as a detriment. In other words, it could be open to a claimant to bring a dismissal claim under both Part 10 and Part 5. The draftsperson has included an express provision excluding the relevant detriment section from applying to a claimant employee where the detriment amounts to dismissal within the meaning of Part 10. So in our example, if we look at 47.2, the exclusion provision that appears at page 73 of the Supplemental Authorities Bundle, it provides that the section does not apply where the detriment in question amounts to dismissal within the meaning of Part 10. And I ask the court to note that those words are identical to the equivalent provision in respect of whistleblowing detriment, i.e. 47B2B, the second limb of the exclusion. Your lordships and your ladyship will have noticed that, of course, there is also a requirement that the claimant is not an employee for that ouster to apply in a protected disclosure case, but I'll shortly return to that. So it's important to keep in mind at this stage that some Part 5 rights apply to workers, some only apply to employees. Let's look at a second example. The second example is the working time detriment, section 45A, and you've already looked at the parallel provision, which precludes and makes unlawful, automatically unfair, a working time case at 1676 of the Authorities Bundle. But the position in relation to working time is that with effect from the 1st of October 1998, a worker has a right not to be subjected to any detriment or any deliberate failure to act by his employer done on the ground that the worker had refused to comply with the requirement that the employer imposed or proposed to impose in contravention of the working time regulations, or indeed any of the other matters that are set out in that section. You'll see that the specific categories are identical to those that I took you to a few moments ago in respect of section 101A of the Employment Rights Act. And the provision ousting a detriment that amounts to dismissal within the meaning of Part 10 is set out in 45A4 in identical terms to the provision in our case, section 47B2. In other words, if the claimant is a non-employee worker, the disapplication of 45A does not apply, and so the non-employee worker can bring a claim of detriment, dismissal as a detriment, but an employee cannot bring a claim of dismissal as a detriment. The third example is, of course, this case, the protected public interest disclosure provisions relating to protected disclosures. And this is chronological. The employee representative's case was one that was originally instituted. The working time provision was one that came into force before the protected disclosure provisions in this case. Now we're looking at the 1998 Public Interest Disclosure Act, which came into force the following year. And it would have been open, of course, to Parliament when legislating to create a freestanding act of its own to enforce these provisions, or it could have placed all the new provisions in Part 4 of the Employment Rights Act. But the route chosen was to go with fitting into the framework that already existed, detriments under Part 5, dismissals under Part 10, with the same sort of interpretation. Now, the long title to the 1996 Act, as set out in the case of Fessett, was an act to protect individuals who make certain disclosures of information in the public interest, to allow such individuals to bring action in respect of victimisation and for connected purposes. And we see that in the case of Fessett, which appears at page 705 of the Supplementary Authorities Bundle. And so that means that a claim in respect of a protected disclosure could originally be pursued only against an employer under Part 5 and by a worker, and the reference in section 48(1)A is that a worker may present a claim to an employment tribunal that they have been subjected to detriment in contravention of section 47B. That's at page 79 of your Supplementary Authorities Bundle. By contrast, a claim that an employee had been dismissed by his or her employer because they made a protected disclosure could only be brought under the provisions of Part 10, in particular section 103A, which appears at page 97 of your supplementary authorities bundle. And the exclusion follows the now familiar form that an employee, just to take a step back, in respect of the right to claim unlawful detriment on workers, the extended definition in section 43K is instructive here. That's at page 75 of your supplementary authorities bundle. So in respect of protected disclosures, worker was given a yet wider definition, covering not only those who were workers under the section 233 Employment Rights Act definition, but also those who are not, where they appear in certain further specified categories. So at section 43K1A, which is at page 60 of your supplementary authorities bundle, it includes those who are in particular agency arrangements. At section 43KB, it includes those who are mostly in other NHS-related capacities, such as performing services under contract with NHS England, or undertaking certain types of work experience pursuant to a course of NMC-approved education, which is at section 43KD. So certain individuals are specified as workers for these purposes, but interestingly, certain types of working people are specified as being employees for these purposes, which has certain consequences. Section 43KA, which is at page 62 of your supplementary authority bundle, categorised police constables and cadets are treated as employed under a contract of employment and are treated as employees for the purposes of Part 4, Section 47B and Section 103A, and for other provisions of Part 10 concerning the unfair dismissal of an employee under Section 103A. Now, what does this mean? It means that insofar as whistleblowing is concerned, the various provisions of the Act specify to a very great degree of granularity that not only employees have certain different rights than workers, but also they provide certain specific sections in which the Act funnels working people to determine who should be treated as a worker and who should be treated as an employee for these purposes. Now, Section 47B has the same disapplication regarding dismissal in the case of employees as we've seen in the working time case, where the detriment in question amounts to dismissal within the meaning of Part 10. And the disapplication works by disapplying the entirety of the section. So once you get to 47B2, if there had been liability before, there is no liability thereafter if Section 47B2 bites. And it uses the same language in each of these provisions where by disapplying the entire section where the two conditions are satisfied, i.e. is the claimant an employee and does the detriment in question amount to dismissal within the meaning of Part 10. Now, my fourth and final example here is Section 44, health and safety cases. You will recall, no doubt, that Lord Justice Underhill referred to health and safety cases in his explanation of the background in Osipov. But things have moved on since the days of Osipov in relation to Section 44. And we say this too is indicative of the correct interpretation of these provisions. So Section 44, which appears at page 67 of the Supplementary Authorities Bundle, prohibits subjecting a claimant to a detriment on grounds which I'll summarise as being in health and safety circumstances. And Section 100 provides a parallel right which prohibits dismissal of an employee on those same prescribed grounds, which you will see at pages 1670 of the Authorities Bundle just handed up after lunch. Now, originally, the protection against detriment relating to health and safety cases under Section 44 applied only to employees, and that's what Lord Justice Underhill notes at paragraph 14 of his judgment at page 157 of the Core Authorities Bundle. However, a new section 44(1)(a) was inserted on the 31st of May 2021, which appears at page 68 of the supplementary authorities bundle, which has extended those rights to workers. And so this has led to consequential amendments in respect of their equivalent of 47(b)(2), the disapplication provision, which appears at section 44(4) in relation to detriments amounting to dismissal within the meaning of part 10. Just as a side note, and it's not in the bundle, but this insertion followed a judgment of Mr. Justice Chamberlain in a judicial review case of the International Workers' Union of Great Britain and Secretary of State for Work and Pensions and another, in which it was concluded that there had been a failure to properly implement EU directives on this subject. It is noteworthy that the identical wording was used in section 44(4). So section 44(4) originally, because it only applied to employees, just had the familiar reference to the section is disapplied if the detriment in question amounts to dismissal. But once it was extended to include workers, it was then updated so that it read that the section does not apply where the worker is an employee and the detriment in question amounts to dismissal within the meaning of part 10. So taking all of those matters together through that tour across section part 5 and part 10, we can say that throughout the lifespan of unfair dismissal rights, only employees have had the right to claim unfair dismissal. And for rights not to be subjected to detriment on prescribed ground, each and every one of those has a disapplication where the detriment in question amounts to a dismissal. And, more importantly, for those that apply to workers and not just employees, the disapplication is in identical terms to section 47(b)(2) under consideration in this case. That's true of provisions which applied from the inception of the Employment Rights Act, such as 47(b), a detriment on employee representative grounds. It applies to those later added, such as working time cases, such as 45A. It applies to the PEDA provisions, and it also applies to provisions where the extension to include workers has taken place after section 47(b) was introduced, including the provision which has post-dated the Osipov judgment, by which I mean section 44(1)(a). So in summary, before, during and after the passage of section 47(b), and indeed after the passage of these post-FESIT provisions, the 2013 provisions that the court needs to look at today, section 47(b)(1)(a) through to (b)(1)(e), at every juncture, Parliament has been absolutely consistent and kept sacrosanct the different regimes that apply to workers and employees, so that for employees, claims against employers must be brought under Part 10 if they concern dismissal, and must be brought as detriment claims under Part 5 if they amount to anything other than dismissal. And by contrast, for non-employee workers, claims for dismissal cannot be brought under Part 10 at all, and all claims must be brought as detriment claims under Part 5, regardless of whether they are for detriment or for dismissal, which might properly be called termination of their contract. So we say that the backdrop to this carefully worded exclusion provision in section 47(b)(2) has to be viewed through the lens of those equivalent provisions across the Act, which form the foundation of the overall structure. And that is what might be called the Employment Rights Act, one route to claim dismissal against the employer. So that's the position in relation to employees. To complete the picture in relation to workers, meaning non-employee workers, for them, they too only have one right to claim dismissal against the employer, as I say, because they have no rights under Part 10. So if they wish to challenge the lawfulness of their dismissal, they can only do so under Part 5, under the detriment provisions, and that remains the position. Now, there's one further point I wish to add, and that relates to a matter that a provision that went into the bundle, but unfortunately in the wrong version. And I hesitate to tax the court's patience by handing up even a further page. But if I may, I don't know if there's anyone kind enough who might be able to do this. Thank you. Thanks. So this concerns Section 197 of the Employment Rights Act, which relates to fixed-term contracts. Fixed-term contracts, the position was, in summary, that there was a special category of employee once upon a time that did not have unfair dismissal rights, and that was an employee under Section 197 of the Employment Rights Act. And as a result, where they were unable to claim unfair dismissal, the content of Section 47B2 reflected that in relation to the carve-out for employees, that carve-out under 47B2 did not apply if we were talking about an employee who was a fixed-term employee who fell under Section 197. And that is covered in Lord Justice Underhill's judgment in Osipov at paragraphs 17 to 18, which appears at page 158 of the Core Authorities bundle. So in respect of that group of employees alone, they could, if dismissed on a prescribed ground, bring a claim under Part 5 relying on dismissal as a detriment. But once fixed-term employees were permitted to bring unfair dismissal claims under Part 10, the terms of Section 47B2 were amended to exclude that carve-out Section 197. And the point that I wish to make is that for those Section 197 employees, they too only had one route to claim dismissal against their employer. And that was, in respect of the time before they had a right to claim unfair dismissal, it was through Part 5. Once they were given the right to claim unfair dismissal, Section 47B2 was changed and they were permitted to claim under Part 10. Now, turning to the backdrop of the 2013 changes. The 2013 changes were enacted following the identification of the lacuna in the provision in Fessett and NHS Manchester, which is at tab 35 of your authorities bundle at page 703. And a little background may be of assistance here in terms of the facts. There, the claimants were nurses who were whistleblowers who were subjected to unpleasant treatment by fellow staff at the centre where they worked after they had made protected disclosures. And they claimed that their employer was vicariously liable for those acts. The Court of Appeal held that the employer could be vicariously liable only for the legal wrongs of its employees. And since there was no provision in the Employment Rights Act making it unlawful for fellow workers to victimise whistleblowers, and since that was the sole basis on which the alleged victimisation was asserted, the claim that the employer was vicariously liable failed. And that is set out at paragraphs 6, 32 and 35 of the Fessett judgment. Lord Justice Elias identified that it was a notable feature that workers were protected against acts and omissions by their employer, not by fellow workers. He set out the applicable test of vicarious liability, being a common law principle of strict no-fault liability, and he drew a contrast between the position under the ERA and the position under the Equality Act. Now, in that case, as in this, there were trenchant calls by the appellants and by Protect that the court should find a solution to what was described as being a gross injustice of innocent claimant whistleblowers being subjected to a detriment, and an appeal to the fact that the law must have intended to have protected whistleblowers in these circumstances and properly protect the public interest. But there, as in this case, we say that the approach of Lord Justice Elias is similar to the approach that should be adopted by this court, that what is being asked for goes far beyond the legitimate role of the court in construing legislation, as Lord Justice Elias found at paragraph 58 at page 717, and that the long title in the Public Interest Disclosure Act did little to assist in terms of understanding the extent of the legislative purpose, given that the Act provided no indication as to how full the protection was intended to be, and that if there was any step to be taken, that was a step that needed to be taken by Parliament and not by the court. Now, the judgment in Fessett was duly overturned by Parliament in 2013, which led to the insertion of the provisions subsections 1A to 1E in Part 5. And I won't go through what each of those means, given Mr. Solomon's explanation already. But I do pick up that in Osipov, Lord Justice Underhill noted that the essential effect of those provisions was to provide a route to vicarious liability on the part of the employer. That's at paragraph 30, page 162, in order to fit the Fessett gap. And that the route...
Sorry, say that again. A route to vicarious liability in order to...
fit the Fessett gap. And that the route taken was that the individual was rendered liable in their own right, irrespective of the liability of the employer. Now, notwithstanding those changes that were introduced, the overall scheme of the legislative framework at issue in this appeal remained unaltered, by which I mean Section 47B2 stood entirely unaltered, and we say, obviously, continues to exclude the entirety of Section 47B from operating in the case of an employee who complains of a detriment that amounts to dismissal by the employer. Now, turning to my second heading of how this legislative scheme has been interpreted by the courts, I want to take this court through two Court of Appeal judgments, Melia and Magna Kansai. Melia is at tab 1 of your core authorities bundle, and Timothy Sage and Osipov, and then to look at Wicked Vision. Now, Timothy Sage, as I say, was not the first time that the Court of Appeal had to interpret the meaning of Section 47B2. That was first considered in 2006 in the case of Melia, and there the employee brought detriment claims under Section 47B, and also brought a constructive unfair dismissal claim under Section 103A. The detriments that Mr. Melia relied on were those matters that he also relied on as amounting to repudiatory breach of contract, which gave rise to the constructive dismissal claim. Both of his claims were successful, and the Court of Appeal considered whether the losses that flowed from his pre-dismissal detriment, which caused the constructive dismissal, were properly recoverable under Part 5 or Part 10, or indeed at all. And Lord Justice Chadwick gave the leading judgment in that case, with which all members of the court agreed. Those members of the courts were Lord Justice Smith and Lord Justice Wilson, who subsequently gave judgment in the case of duty, that I'll also turn to shortly.
Lady Justice Smith.
Sorry, Lady Justice Smith, I do apologise. Lord Justice Chadwick identified at paragraph 15 of his judgment, this is at page 8 of the Core Authorities bundle, that Section 47B and 103A spring from the same root, that they are parallel elements in the protection which Parliament has given to whistleblowers, that the sections would in any event be read together, if only because they are now sections of the same Act, i.e. the Employment Rights Act, but the fact that they sprang from the same root, the 1998 Act, and the fact that Section 47B is made subject to the limitation imposed in 47B2, with Section 103 in mind, led irresistibly to the conclusion that the two provisions were intended to be complementary. And he said, to put the point more simply, Parliament did not intend to confer a right under Part 5 of the 1996 Act for the protection of whistleblowers in circumstances where the worker, being an employee, would have a right under Part 10 in respect of the same loss or detriment. And subsequently, in that judgment, at paragraphs 32 to 34, which appear at page 12 of your Core Authorities bundle, on the meaning of when a detriment can be compensated for, he concluded that the proper meaning to be given to the phrase "the detriment in question amounts to dismissal" is that it excludes detriment which can be compensated for under the unfair dismissal provisions if the detriment cannot be compensated under the unfair dismissal provisions for the reasons that it is not a loss sustained in consequence of the dismissal, then there is nothing to take it out of section 47B, and the provisions in section 49 which require compensation for detriment should apply. So in other words, Lord Justice Chadwick concluded that the effect of section 47B2 was to provide a complementary, mutually exclusive, interlocking scheme of liability where one cause of action did not trespass on the other. And the dividing line rested on whether or not the compensation could be claimed under Part 10 of the Employment Rights Act or not. And that judgment, we say, remains good law and is a clear articulation of the scope of section 47B2 and the ouster that it provides. Now, turning to Osipov, it's against that backdrop that we consider Osipov and then Wicked Vision. I'm conscious that you've already been taken to a number of these sections, and so I'll deal with it more briefly. But Lord Justice Underhill explained the scope, and this is relevant both to Ground 1 and Ground 2, of the appeal expressly in his judgment. Paragraph 35, page 164 of the Core Authorities Bundle, says in terms, "This appeal is however concerned with the detriment claim, and more specifically with the claim against the appellant directors that in breach of section 47B they subjected the claimant to detriments which led to his dismissal." So we ask you to put a large arrow next to that. So that's important in terms of understanding the scope of the ratio in the claim, the issue that was before Lord Justice Underhill and the other members of the Court of Appeal in that case. He made a similar point at paragraph 5, which is at page 155 of the Core Authorities Bundle, but I won't take you to that now. Then under the heading "The Appeal" at paragraph 46, which is at page 166 of the Core Authorities Bundle, he says that the director's appeal against the decision of the Appeal Tribunal. And of course it's a simple point, but the case itself is called Timmis and Sage against Osipov. No mention of IPL, the employer, because IPL was not party to it. And under that heading, "The Appeal," where he says the director's appeal against the decision of the Appeal Tribunal, namely, A, by reason of section 47B2, neither T nor S could be liable to the claimant in respect of an instruction to dismiss, nor under section 47B2 could they be liable for losses which flowed from the claimant's dismissal, and B, in any event, Mr. Sage could not be liable to the claimant in relation to any instruction, and so on. Now, in that case, Mr. Stillett's KC represented the directors, and he explained at paragraph 58, which appears in your Core Authorities Bundle at page 170, that the detriments that were pleaded amounted to dismissal. And at paragraph 60, Lord Justice Underhill agreed, but said that this only got Mr. Stillett to first base. He considered that the claimant's argument that 47B2 wouldn't apply to the claim as against the directors, as opposed to IPL in the second sentence, and that dismissal within the meaning of Part 10 is a right only against the employer. He, in his view, a complaint against under section 1A against an individual who's a party to the dismissal fell outside the scope. I want to take you next to paragraph 70, where Lord Justice Underhill says at page 174 that in respect of the choice of scheme, a choice was made not to disturb the existing unfair dismissal scheme, but to create a complementary scheme covering detriments other than dismissal, but that there was no reason to think that there was a great conceptual gulf between dismissal and detriment, and that the policy was unlikely to be anything more that one cannot claim under Part 5 where an identical right was available under Part 10. Now, what you have seen in relation to the architecture is perhaps more than what Lord Justice Underhill saw in relation to the case of Osipov, and of course he did not have the benefit of the change of provision in respect of Section 44 on health and safety cases, where we can see that whatever the gulf is, it's a gulf that Parliament has guarded very closely and protected at every turn. Now, paragraph 71 is one where Lord Justice Underhill says that he had no reason to suppose that the policy changed when the Public Interest Disclosure Act was introduced, and Section 197, which I've already referred you, shows it did not, and there's no reason to suppose that the policy changed by the 2013 Act. In other words, that separation was intended to remain.
I'm so sorry to interrupt. I've just gone back to the end of paragraph 70. Last sentence, Justice Underhill was referring to the anti-overlap provisions. Policy behind it is unlikely to have been anything more than that the claimant should not claim under Part 5 where the identical right is available under Part 10. Does he say where that conception of the policy comes from, or is that just his conception of the policy?
There's unfortunately nothing that indicates where that comes from.
Right.
And of course, a claim under any other part is not an identical right, wouldn't provide identical remedies. So that is something of a mystery.
Right. So you're Mr. Byzine?
Yes.
Right. Thank you.
These are necessarily different. They are different causes of action, but the test in Section 47B is about whether or not the detriment in question amounts to a dismissal. And that question of amounting to a dismissal is an invitation to look at Part 10, which is all about, obviously, dismissals and whether or not those are dismissals under prescribed grounds. At paragraph 72, Lord Justice Underhill refers to the problems that were raised by Mr. Stillitz as anomalies, namely that in detriment claims it was possible to recover injury to feelings, and there was a different test of causation, but describes those as wrinkles in the scheme without wider significance. And he suggests that there's no indication that the draftsman focused on this at all. That might be something of an understatement, given the legislative background to which we have referred, and indeed the canon of construction that one presumes that Parliament has acted in a rational manner, and one presumes that Parliament has not made mistakes. Then at paragraph 75, Lord Justice Underhill decides against a literal construction of Section 47B2 and says that he would have expected Parliament to have excluded liability under the operative provisions of the section only where the identical remedy was available under Section 103A, and that it wouldn't exclude a co-worker's liability for the detriment of dismissal under subsection 1A, or, and then he puts this in parenthesis, which I say is in itself revealing, which follows any vicarious liability of the employer under subsection 1B. So we say as to that the part that's in parenthesis is in parenthesis because Lord Justice Underhill appreciates that that's not the matter that is before him in that case. And he's setting out his understanding as to how Parliament would have approached the matter, essentially saying that when it comes to excluding liability, he did not see that it would be appropriate to exclude a co-worker's individual liability for detriment under subsection 1A.
And we see a repetition of this idea that this reference to identical remedies,
Yes, and indeed to his own
for
expectation.
which there is no obvious source in the statutory language.
No, indeed. Indeed, my ladyship, that is right. And it is against that backdrop at paragraph 75 that in the final two sentences at page 176, he concludes that a claimant relying on subsection 1A could indeed say, I'm not complaining of an act done by the employer, but of an act done by my co-worker. And he concluded that that was a more rational and coherent statutory scheme, one that permitted such a claim, and that conformed better with the purpose of section 47B2. Now, so that it is, yes, so then we come to how Lord Justice Underhill describes what we say is the ratio in this case. I would accordingly hold that section 47B2 does not prevent the claimant proceeding against the appellant directors under Part 5 on the basis of their responsibility for the dismissal itself. And then he goes on to say about how this otherwise produces something of an inelegant result or is clumsy. Now,
I don't want to add to the pedantry that can arise around the issue of ratio. So, but 77 is really a statement of the conclusion or decision, is it not? I'm not
yes.
taking, I'm not seeking to take issue with the point that
yes.
you're making, but you described it as containing the ratio.
Yes.
It doesn't actually contain the ratio. It actually just tells us what the conclusion is, and that's a very good thing to have in a judgment, to know
it is.
what the conclusion is. You read a lot of judgments and they don't find it.
It is.
So
yes, I think you're quite right to make that point.
I think the ratio is the reasoning, and the extent to which it's essential reasoning, or the extent to which it's part of the reasoning and so forth, is all part of the materials that we were taken to before lunch.
Indeed, I think a better way of describing it is to describe the scope of the appeal in this particular case.
It's what they decided.
Indeed.
You would put it.
Indeed, that's right. Thank you.
But the ratio and what they decided are not synonyms.
I agree.
Right. Okay. So long as we're on the same page, I don't want to press that point further.
We are, my lordship. Thank you. And then if we look to paragraph 90, obviously I can't cover all the paragraphs in this case, but at paragraph 90 we deal with essentially the conclusion provision in relation to Melia. Melia I've already taken you to. I say that it's an important judgment which deals specifically with section 47B2, and Lord Justice Underhill had begun his consideration of Melia at paragraph 85 of the judgment, which is page 178 of your core authorities bundle, saying that he deliberately postponed considering it until this stage, and then having looked at Melia, he concludes that in Melia, this is at paragraph 90, page 180 of the bundle, that Lord Justice Chadwick was dealing with a different question to the one before him. Obviously, he's dealing with a question about liability under section 47B1A. And in the middle of that paragraph, between F and G, it says Chadwick LJ's analysis and mine of the policy behind subsection 2 are broadly the same, but he refers to the same loss or detriment, whereas I refer to the identical claim. So, my ladyship, to the extent that there is some further explanation as to what identical claim might mean, this might be one such contender. And he says that that language used by Lord Justice Chadwick was appropriate in the context of the 2013 legislation, but that a more refined approach was necessary because of the possibility of having claims against different respondents. So that's what he says he means by identical claim. Now we'll come on to into a moment to the case of...
Do you read the last sentence as well of that paragraph?
that issue was not before the court. Sorry.
Yes, please.
Yes.
Yeah.
Yes, we can all read that.
Yeah.
Obviously, this Melia, as I explained earlier, was a case of constructive unfair dismissal brought against the employer pre-2013, and obviously in the case of Osipov, that's about the 2013 regime. And so he says that Chadwick's language cannot be treated as having a bearing on the question which we have to decide.
So that was distinguishing Melia on the basis that the issue was different.
Yes, that it
So
wasn't.
to that extent, you rely on that to say the issue is different here to the issue in Osipov.
Yes, indeed, that's right.
Do you accept the issue in Amelia was materially different, or is it your submission that actually the reasoning in Amelia is relevant?
Well, we say that the question about the same loss or detriment, that reasoning survives, we say, Melia, because that is the essential exercise that should be undertaken, whether it's about Section 47B1A or a Section 47B1 claim, which is just brought against the employer. But we can see what Lord Justice Underhill's position was on that there.
Thank you.
And then we come to paragraph 91, where Lord Justice Underhill describes his essential conclusions. And he describes that it's open to an employee to bring a claim under Section 47B1A against an individual co-worker for subjecting him to the detriment of dismissal, i.e. for being a party to the decision to dismiss. And I should pause there and say that before this court, Wicked Vision does not take a different point on that. It was open to bring a claim under Section 47B1A against a individual. We don't say that Lord Justice Underhill was wrong to reach that conclusion in Osipov. We say that this court is bound by such a conclusion, but where Lord Justice Underhill has gone further and says, and to bring a claim of vicarious liability for that act against the employer under Section 47B1B, that is something that went beyond the occasion. And that is something that we say is not ratio in Osipov and is wrong because Section 47B2 bites on Section 47B1B claims for reasons that I'll come on to in a moment. And then we see that Lord Justice Underhill's position is that all that 47B2 excludes is a claim against the employer in respect of its own act of dismissal. But the misinterpretation here is that a claim under Section 47B1B is treated as an act of the employer, and so we say that it amounts to a dismissal within the meaning of Section 47B2, properly understood.
So can we just, because we're going to be looking closely at a few of the paragraphs in Osipov, which this is obviously one, we just understand exactly what you're saying about the three limbs of 91.1. I've clearly understood that you've said that the first limb, as we're up to the semicolon, is fine.
First limb is fine.
Yes.
If that is what happened in Osipov,
Yes.
the directors were permitted to bring a claim against the directors for being party to the decision to dismiss.
We have that. But you told us in relation to the second limb that it went beyond the occasion.
Yes.
To use your phrase. But is it your case that it's in fact incorrect?
Yes.
Right. So it was superfluous and wrong.
Yes.
And what do you say as to the third limb?
That Section 47B2 excludes a claim against...
All that it includes.
All that it excludes is a claim against the employer. Well, we say that on one reading of that, excluding a claim against the employer in respect of its own act of dismissal is not only a claim under Section 47B1, i.e. acts or omissions on the part of the employer, but would also, 47B2 would exclude acts of dismissal by the employer which are deemed acts of the employer.
Vicarious.
Vicariously.
Right. So that also falls under your acts. The third
Yes.
limb. That is, as the second limb is unnecessary to the decision and incorrect
Yes.
on your submission.
Yes.
Good. Well, that's useful to be able to keep those lines of sight clear.
Certainly. Now, I want to move on, please, to the case of Wicked Vision that is before you now. This EAT decision was an appeal against an employment judge permitting the claimant to amend his claim. And Mr. Justice Bourne dealt with the statutory framework again in that case. And he identified at paragraph 16, this is page 208 of the Core Authorities bundle, that as a result of the 2013 changes, a detriment claim can now be made against a co-worker, and it can be made against an employer on the basis of vicarious liability, subject to statutory defences such as reasonable steps. But Section 47B2 continues to provide that the section as a whole does not apply where the detriment in question amounts to dismissal.
Just remind me of what paragraph you're reading from there.
16, my lord.
Thank you.
Page 208.
Yes.
So it is not accurate or correct to say that if one wants to know what is the extent of liability, vicarious liability or individual liability, that all you look at are the newly inserted provisions from 2013, i.e. Section 47B1A through to 1E. Section 47B2 continues to apply, and where that bites, it bites in respect of Section 47B1A onwards in the same way that it would bite in respect of any other part of Section 47B, including Section 47B1. Mr. Justice Bourne identified that the issue was one of statutory construction and whether Section 47B can found a claim against an employer arising from a Co-Workers Act amounting to dismissal. That's set out at paragraph 24. So he had clear in mind the core question that was necessary. That's at page, 210, thank you. Paragraph 24, my lord, at the bottom of the page under the heading discussion. And he goes on to explain that TIMIS, this is at paragraph 25 on the next page, is authority binding on this tribunal for the proposition that a claim can be brought against a co-worker under Section 47B1A, even where the Co-Workers Act amounts to dismissal.
So and that's the first part of 91.1.
Yes, that's right, before the semicolon. And he says at first sight that proposition seems to sit uneasily with Section 47B2. And then he goes through why that is, in fact, a decision that is a sound one. And he explains at paragraph 30 on the same page that Lord Justice Underhill rejected the idea that the separation of Part 5 and Part 10 regimes reflected any great conceptual gulf, and that anti-overlap provisions were required in the interests of good order, but the underlying policy was probably only that a claimant shouldn't claim under Part 5 where the identical right was available under Part 10. And he picks up my ladyship's concern as to the meaning of identical right, noting that rights under Part 10 and Part 5 will seldom, if ever, be literally identical, because of the differences in the causation test. Pausing there, there is a lower causation test under section 47B than there is under section 103A. Essentially a reasonable principal reason test under section 103A as compared with done on the ground that amounts to a material influence, a much lower test under 47B. And because remedies will be different. And pausing there, the remedies could be different because in a unfair dismissal claim, one has the right to obtain a basic award, which one doesn't in a detriment claim. One may obtain...
One can always find some distinction.
Always find some distinction, that's right.
Could I, having interrupted you, could I say that this is as all the submissions are, but this is extremely helpful, but it's quite dense, this appeal.
Yes.
So what I think we'll do is within the next 5 or 10 minutes, we'll have a mid-afternoon break.
Yes, of course, thank you.
And would you like to just choose what seems like the best moment to you, if indeed it isn't now?
Thank you. I think maybe 1 or 2 minutes more
By all
before.
means.
Thank you. Just to finish off this point. And so he says that there will be differences, and moreover that these are differences that Lord Justice Underhill was obviously well aware of. And he goes on to say that what he understood Lord Justice Underhill to mean was that a claimant who had a claim under section 103A could not choose to repackage it as a claim under section 47B. And let me... Sorry? Thank you. Thank you. That's at paragraph 38.
Yes.
And he says that remedy in the technical sense would hardly ever be identical under sections 47B and 103A. What he meant is that a claimant couldn't repackage it as a claim under 47B. And going back to the submissions I made regarding the architecture, setting that out, this is about the claimants have one route to claim dismissal. And so the sort of claim that was being put forward here...
One route to claim dismissal as against the employer.
As against the employer, yes. And so in Timmis, the situation didn't arise because the issue there was about a claim against the employers, not the company, and the claim against the directors obviously couldn't be brought against section 103A. But essentially, the position is this, that dismissal, any dismissal is necessarily an act of the employer, even if it might also be said to be with the involvement of a co-worker. So in all cases, if a co-worker is involved in dismissing an employee, that dismissal is in any event also an act of the employer for which an employer is already liable, regardless of whether they seek to bring a claim against their individual co-worker, either instead of or as well as the employer. And that's true whether the co-worker is a line manager, a director, a chief executive, or indeed somebody else. And so the claimant's putative claim under section 47B(1)(b) is one which self-evidently could be brought as a section 103A claim, challenging the lawfulness of their dismissal. And so I think that probably is a good place to pause. My Lord, thank you.
You're doing all right.
Yes, I think so. Thank you very much.
All right, table.
How long have we got? 10 minutes? 4:30, no?
I think we don't need 20 minutes.
I think it was 5. I got the sense of 5 minutes or so.
Oh, right,
Yeah,
okay.
5 to 10 minutes.
All of the break is 5 to 10 minutes.
Yeah, okay.
Great, thank you.
How are you doing for time?
Yeah,
Obviously not having reported, so I think
Yeah.
what do you think you've got, if you had to guess? An hour? I think so. Well, don't really. I mean, I think I'm a job. Such a lot of submissions that I quite like.
Yeah.
But no, I think it's actually. I mean, the statutory scheme. That's what I think.
Thank you. Thanks very much.
I don't know if you want to say that's right.
Thank you. Thank you. Always appreciate it.
Yeah, but I think that's would be right. And I mean, they didn't interrupt.
No, they didn't interrupt it. That's
They're clearly interested.
yeah. Right, let's just... Is there any way we could get some water? Because I'm going to run out and I'm doing quite a lot of talking. So.
Is there a drinking fountain out there? Because we've got.
You can check and see, but I'm not sure. I'm not allowed to report on the
Oh, right.
We'll
So,
just see.
thank you.
So we could.
Can you head up? Oh, hi. That's good.
Can I grab one of these jugs? I'm just going to fill it up in the bathroom.
No, I'm gonna fill it up now. Just wait for
Oh,
someone
okay.
to cover me quickly.
Yeah, sure. Okay.
I'm gonna fill it up.
Yeah, okay. Thank you.
Uh,
Sorry, everyone's like very
Really?
warm and thirsty.
She's right, hospital's wrong. Yeah. Wrong. That's not she's wrong.
Sorry, Christian.
Let's respond. She's also
What, rise of April?
Thank you. Just, I'll ask you to note, if I may, two final provisions, two final paragraph numbers in Mr. Justice Bourne's decision in Wicked Vision. So that's paragraph 41. Where that is at page 213, which is where Mr. Justice Bourne explained what he understood the ratio of the case to be. And paragraph 54, sorry, 42, which follows on from that, that although Lord Justice Underhill contemplated vicarious liability of the employer would or could follow from the co-worker's liability, the position of the employer wasn't at issue in the case and forms no part of the ratio. And then paragraph 53 of the judgment, where he concludes that his decision was not based on the absence of a concurrent claim, and 54, where he refers to effectively adopting what Lady Justice Simler said in the case of Osipov in the EAT, at paragraph 144, which was what was necessary to do was to scrutinise the proposed claim against the employer and ask whether it was based on what Lady Justice Simler described as detriments amounting to dismissal within the meaning of Part 10. In other words, detriments amounting to unfair dismissal claims necessarily against the employer. And for the reasons that I've already identified, a claim regarding a dismissal would necessarily amount to an unfair dismissal claim necessarily against the employer. So I'll leave it there with the references to the Wicked Vision case for now, and address you on.
Can I just ask you this? If one is doing a case-by-case approach, like paragraph 54 suggests, in order to decide in substance what this claim under Part 5 really amounts to, is that
Yes.
That's what's being suggested? I mean, the instant claim he thought was one where the employer and the co-worker were much one and the same thing.
Yes.
But you might have another case where it was a more lowly co-worker who couldn't be regarded as being the alter ego of the employer. But nevertheless, it would all find its way back to the employer through the vicarious liability statutory scheme. I'm just trying to work out how, if you took a different case of the humble employee.
We say that whichever case that is adopted in respect of a dismissal by a co-worker, one would end up in a position where it could be repackaged as a Section 103A claim, because it is fundamentally a claim about the dismissal of that employee.
Right, so it doesn't depend upon the level of identity between the co-worker and the...
Certainly not.
The employer.
No.
So when he says the question in this case could only receive an affirmative answer, I may not be reading this carefully enough, but it suggests that in another case it might receive a negative answer, or are no negative answers available.
We say that no negative answers are available.
Right, so he's not setting up the idea that you look at it and you say, well, this is really a claim for dismissal, which is not a Part 10 claim masked
Yes.
and repackaged in order to for some advantage through Part 5.
Yes.
It's a genuine freestanding individual claim, albeit for dismissal.
Yes, we say that
No such case exists.
No such case exists. We say all cases which involve the dismissal of an employee will be ones that could be brought as repackaged 47B claims or repackaged Section 103A claims. So what was being brought out there is that there is a degree of absurdity in trying to flex the meaning of Section 47B1A to bring into focus Mr. Strang as a co-worker, but that is not the basis on which Mr. Justice Bourne has reached his decision.
I'm wondering in that case why go to the trouble of writing 6 lines about this? I mean, the short answer on your submission is simply to say, well, it's a claim for detriment through dismissal. So you're an employee.
Yes.
Well, it may not open to you.
Indeed. Well, he may well have been considering whether there was some other form of defence that was available there, such as a reasonable steps defence. Indeed, because that too would be a way of the employer not being liable before you even get to Section 47B2, if there is a reasonable steps defence. But the key conclusion that Mr. Justice Bourne reaches is at paragraph 47 in respect of this case, because his interpretation of Section 47B2 is one that says that it would be odd if Parliament, while barring a claim against an employer based on a detriment that amounts to dismissal within the meaning of Part 10, at the same time permits precisely such a claim to be made under subsection 1B, in addition to or instead of a Section 103A claim. And that's a very powerful point, because, as he says, in virtually every case involving a corporate employer and in every case where dismissal is decided or communicated by a person who is not legally the employer, that could be the case. And we know that there are no cases, insofar as this council team is aware, of automated decision-making where the dismissal by an employer has taken place through entirely automated means, not involving a human, and brought as a claim by an employee against their employer. These
whole new vistas of litigation.
Indeed, which may well come to the fore. Maybe Mr. Milsom even has one of those cases, I don't know. But, what we can say is that for any case where a human is involved, those are, as I say, dismissal is an act that is necessarily one that, as Mr. Justice Bourne himself refers at paragraph 45, he says that a company's liability for unfair dismissal, so section 103A, could be viewed as vicarious in every sense, because in practice, unfairness can be expected to arise from the act or omission of one or more human beings working on the company's behalf. And so too here, if you are relying on humans to make the decision, to communicate the decision, to implement the decision, then that is an act that would already be a section 47B1 claim under the Act. And so simply it's a detriment to which section 47B2 would bite. And so if one repackages it as a section 47B1A claim, yes, you can have separate claims against the individuals.
This is an argument, is it not, that Osipov was just wrongly decided?
Well, Osipov,
these submissions would lead to the fact that limb 1 of Osipov was wrong, which, I mean, it's possible, but clearly that's not an argument that's open to you in this court.
Yes, well, we're not arguing.
Nobody's seeking to narrow the meaning down beyond the proposition identified by Mr. Justice Bourne.
Yes, which is section 47B1A claims fine. Section 47B1B claims are not fine because section 47B1B still bites. If I can turn then to submissions on ratio, and I'll take this fairly swiftly. I don't intend to take you at length through the authorities, though you have them before you. I think what I can say is that we make essentially 4 core submissions. Firstly, that an interpretation of ratio and obiter dicta are matters of objective analysis, and that even where a judge has described a matter as an essential conclusion, that does not mean in and of itself that all of it, or indeed some of it, certainly does amount to ratio. What is needed is an assessment of whether the so-called ratio amounts to a rule or ruling of law expressly or impliedly treated by the judge as a necessary step in reaching his or her conclusion. Secondly, that in any event is open to subsequent courts at the same and lower levels, as in addition to self-evidently higher levels, to interpret or reconsider the ratio in a given case. And that must be all the more the case where the matter at hand is a matter of pure law, one of statutory construction.
And do you say Churchill's an example of that?
It may be. And thirdly, that the ratio of Osipov does not extend to the conclusions regarding the employer IPL, but was limited to the substance of the appeal described by Lord Justice Underhill regarding the co-workers under section 47B1A and subsequently interpreted by Mr. Justice Bourne, and that the EAT's conclusion was an appropriate interpretation, that there was in respect of claims validly brought for the detriment of dismissal, but that Osipov does not provide a ratio in respect of section 47B1B claims. I'll turn now then to the multi-step process, which we say has to be undertaken under section 47B of the ERA. We say that there is a multi-step process to establish liability on an employer based on the acts of co-workers where the claimant is an employee. The first stage is, did the co-worker subject the claimant to a detriment by any act or deliberate failure to act on the ground that the claimant made a protected disclosure under section 47B1A. The second step is to ask, if so, whether the employer is vicariously liable under section 47B1B, which in turn depends on whether or not the employer has any reasonable steps defence. And the third step is that if they would otherwise be vicariously liable, is section 47B disapplied in its entirety because of the operation of section 47B2, i.e. the detriment in question amounts to dismissal within the meaning of part 10. If the detriment doesn't amount to a dismissal within the meaning of part 10, then the section wouldn't be disapplied, and the employer would remain vicariously liable.
This may not be a sensible question, but why do you start in that order? Why would you not ask the third question first? Save yourself some trouble.
I think that's a fair point. I think one could ask first and foremost, is this an act
Because that would be
on
knockout.
which
That would be a knockout for that part.
it
of
would
the
be a
claim,
knockout?
please.
Yes, I don't say that there is a prescribed order. It would be permissible to look at section
Right.
47B2 first. And looking at what was decided in Ozipov, the court didn't determine whether the employer was vicariously liable under subsection 1B, the second step as I've identified it, and didn't look at whether or not that vicarious liability would be prohibited by section 47B2 at step 3, because IPL was not a party to those proceedings before the Court of Appeal. So we say that if you're doing them in the order that I've taken you through, then it's self-evident that steps 2 and 3 on vicarious liability and the application of section 47B2 were not necessary steps in order for Lord Justice Underhill to reach the conclusion on the first step regarding the liability of the co-worker. And so the ratio does not logically include steps that were not in issue. I'll move now to statutory construction and submissions on ground 2. And the overarching point to make here is that this case does not involve any novel approach to statutory interpretation, and it doesn't require any extensive analysis of the authorities on statutory interpretation. But what is required is a close analysis of the overall statutory sections, their position in the Employment Rights Act, and the coherence of the Act overall. Turning to the most recent of the authorities in the authorities bundle, for Women Scotland in the Supreme Court, Wicked Vision, the Respondent, adopts the position set out in that case by the Supreme Court, in particular at paragraph 9 onwards, which is page 857 of the Supplementary Authorities Bundle, as set out in the opinion of Lord Hodge, Lady Rose and Lady Simler, who cited from the case of R on the application of O and the Secretary of State for the Home Department, in which Lord Hodge stated that the courts in conducting statutory interpretation are seeking the meaning of the words which Parliament used, and to identify the meaning borne by the words in question in a particular context. Secondly, that the words and passages in a statute derive their meaning from their context, which must be read in the context of the section as a whole and in the wider context of a relevant group of sections. That other provisions in a statute and the statute as a whole may provide the relevant context, and also identified at page 858, still part of paragraph 29, in the final sentence, the constitutional reason in respect of statutory interpretation that citizens and their advisers are intended to be able to understand parliamentary enactments so they can regulate their conduct, and they should be able to rely on what is an Act of Parliament. So statutory interpretation involves an objective assessment of the meaning. It's not about providing a literal interpretation divorced from context and divorced from the purpose of the statute. And I ask the court to note paragraph 8 of the case of Kintervally, which is cited at paragraph 10 of For Women Scotland at page 858 to 859, in particular the final 2 sentences, that the court's task is within the permissible bounds of interpretation is to give effect to Parliament's purpose, so that the controversial provisions should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation leading to its enactment. I would ask you to note section 11.1 of Benyon, which is at page 1476 of the authorities bundle, supplementary authorities bundle, where context is given its widest possible meaning, i.e. The context of the act of its whole, as a whole, in its legal, social and historical context.
Do you also rely on the first sentence of paragraph 11 of the judgment in the Women in Scotland?
Thank you. If I let me just go back there, thank you. Paragraph 11. I do apologise, my lady. What is the page number that you're looking at?
859. You just took us to
Yes,
the
indeed.
judgment in for Women in Scotland.
Yes, indeed.
You took us to paragraph 10, citation from Quinta Vale, and then
Yes,
I was
indeed.
asking you whether you rely on the first sentence of paragraph 11.
Yes, the general approach of focusing on the words that Parliament has used is justified by the principle that those are the words Parliament has chosen to express the purpose of the legislation and by the expertise of which the drafters of the legislation bring to their task. I do, yes,
Yeah.
certainly. Thank you. And in this case, we say that is admirably clear in section 47b2. And if I can also invite you, I've made reference to this already, but I haven't given you the section of Benyon. It's page 1483, and it is section 11.3. And that is the presumption of an ideal rational legislature, reasonable and informed, pursuing a clear purpose in a coherent and principled manner, with a presumption that the legislation has been competently drafted, including a presumption that an ideal legislature never promulgates a meaningless enactment. And that is under the section headed comment in the second paragraph, third sentence. We say that too is of assistance here. Because of what we say would otherwise be rendering section 47b2 a dead letter, which I'll come on to. So that's the framework for statutory construction. I now address you on the submissions, and we make two interlocking submissions. The position that the position taken in Wicked Vision in the EAT reflects, firstly, the necessary objective assessment of the meaning of the words used in the statutory language, and secondly, that it reflects Parliament's intention, read in the context of the statute as a whole, and provides coherence in respect of the overall statutory scheme. I'll address you on those 2 points, and I'll address you on one further matter, which is the delineation of matters for this court and matters for Parliament. And I won't now address you on the appellant's human rights arguments as they haven't pursued that before you today. So dealing with an objective assessment of the meaning of section 47b2, on its face, it has a plain meaning. And that meaning is that it excludes any claim for dismissal that could have been brought as a claim under Part 10. And that necessarily includes claims that could have been brought under section 95. So, as I've said, the effect of section 47b2 is to disapply the entire section, disapplying 47b1, disapplying 47b1a, all the way through to section 47b1e and any other provisions. It's not an ambiguous provision, and it's capable of one meaning, and it should be followed, in accordance with paragraph 11.9 of Benyon, which is at page 1493 of the authorities bundle.
Can I ask you a question about section 47b2, please? This might not be a convenient moment to deal with it, but maybe I haven't read the judgment in Ossipoff carefully enough, but where does that judgment deal with the meaning of section 47b2?
That,
I mean, it could be that I just haven't read it carefully.
yes, can I return to that in just a
Value your
moment?
assistance on that
Thank
point
you.
of view.
I'll return to that in
Yes,
just a
that's
moment.
very
Thank you very
helpful.
much. Turning to Parliament's intention. Parliament's intention in the Employment Rights Act and in its predecessor statutes was to set out the statutory rights not to be unfairly dismissed, and thereafter to add in further rights not to be unfairly dismissed on prescribed grounds, which are treated as automatically unfair, and not to be the right not to be subjected to detriments in respect of those same prescribed grounds. As I've said, in all cases where there is a detriment, right not to be subjected to a detriment on a prescribed ground, there is an exclusion in some form of any detriment claim being brought for the detriment of dismissal. And we've seen that in respect of section 47B, 44(1)A on health and safety, 45A on working time, etc., and so on. So Parliament has time and again provided identical language where workers who have no rights to bring any statutory dismissal claims under Part 10 can bring detriment claims, but employees who do have such a right under Part 10 cannot. And that's true even though those sections have been enacted at different times and in some cases have been changed over time. As I've said, Parliament's even gone as far as to legislate to funnel certain types of atypical working people, to categorise them into two camps, workers and employees, as I've indicated under section 43K and section 47.3KA, some to use Part 10, some to use Part 5. And regardless of whether the appellant, protect, or the courts consider that this is the most desirable statutory scheme or not, there can be no doubt whatsoever that this delineation and this mutually exclusive set of rights on the basis of either worker status or employee status is a deliberate and key feature of the legislation, and in particular of section 47B and the whistleblowing provisions, which has been replicated time and again. So how should those 2013 provisions be viewed? How should 47B2 be interpreted when a claimant seeks to bring a 1A claim against a co-worker? Is that caught by section 47B2? Elisabeth tells us that it doesn't oust the claim. That is the effect of the Court of Appeal's decision. And we accept that this court is bound by that judgment, albeit that if this matter were to go further, then we would have other submissions to make on the correctness of that conclusion. And as Lord Justice Underhill said in Ossipov at paragraph 32, which is at page 162 of your authorities bundle, the core authorities bundle, the new provisions mean that there is the potential for liability still under the original section 47B1, i.e. the employer's liability for its own act, and secondly, potential liability via vicarious liability under section 47B1B. So what is the position if a claimant wishes to bring a claim on the basis of section 47B1B, relying on vicarious liability based on the co-worker's liability under 47B1A? Why is that caught by section 47B2? We say that first and foremost, to do otherwise would render section 47B2 a dead letter. And Parliament cannot have intended that this exception would be effectively repealed by a side wind in circumstances where there was no change whatsoever to the wording of section 47B2 post-2013. And to read it in the way that's being advocated by the appellants would effectively undermine and dismantle the carefully constructed separation of rights under Part 10 and Part 5. We say that if you look at the statutory provisions, because of the way in which section 47B refers to things that are, B2 refers to matters that where the detriment in question amounts to a dismissal, and under section 47B1B, that where a worker is subjected to a detriment by anything done in subsection 1A, that thing is treated as also done by the worker's employer, then that brings it within the purview of section 47B2. And Mr. Justice Bourne is right to say that it would be very odd if Parliament, while barring any claim based on detriment that amounts to a dismissal within the meaning of Part 10, at the same time permitted precisely such a claim to be made under Section 47B1B.
Could you give a worked example of where I've been dismissed, and I'm a whistleblower, and I'm contemplating how to frame my legal action?
Yes.
I have on the one hand the possibility of going under Part 10 against my employer for unfair dismissal. I have on the other hand the possibility of going against the managing director under Part 5,
Yes.
relying on the vicarious liability provisions, if that's what a correct reading is. You dispute it, but let's suppose I had a choice of going through Part 5, but ending up in recovery against the employer by that route. What might the advantages or disadvantages be for me of the choice one way or the other?
Yes,
If I had one.
well, we essentially say, of course, there is no choice.
No, I
That's
understand
the point.
that. I mean,
But if one did have a choice,
Yes.
such that there was a difference between Section 47B claims and any other type of claim that's under the ERA, because we weren't respected this careful separation, then in a Part 10 claim, one has the advantage of being able to get a basic award, in theory, if not in practice, potentially being able to obtain an order for reinstatement or re-engagement. Those are the advantages.
Wider remedies under 10.
Well, different remedies,
Different remedies.
because one can still obtain compensation for losses arising out of the dismissal, consequent on the dismissal. Those same losses consequent upon the dismissal would be recoverable under Section 47B1 or other sections of Section 47.
Would the amount be at large under Section? Assume a claim were available under Section 47B. Would the amount of the compensation be subject to any limit?
Yes. So the compensation would be subject to a limit because, in respect of dismissal, because there is a provision that sets out, I think it's 48(5), I would need to check, which is effectively a limitation, so that, yes, it's 49, it starts at page 81 of your supplementary authorities bundle, and it's a subsection 6. So where the complaint is made under Section 48(1)(a), that's the provision that permits claims for detriment in respect of protected disclosures, and the detriment to which the worker is subjected is the termination of the worker's contract, and that contract is not a contract of employment, compensation must not exceed the compensation that would be payable under Chapter 2 of Part 10 if a worker had been an employee.
So they mesh
Yes. So even for a worker who undisputably has the right to claim compensation arising out of the termination of their contract as a worker, as a detriment under 47B, their compensation cannot exceed the compensation that they would have got had they been an employee and claiming under Section 103A.
But I was being a bit more subjective. I was just trying to put myself in the position of somebody who was trying to plan their litigation.
Yes.
And what if anything, might lead me to go under Part 5?
Yes,
If
well,
I've been dismissed.
the most important thing that would, if you want to shoehorn your case into Part 5, the main benefit is that the test of causation is different and lower. And so...
I don't need the detail, I know, broadly speaking, what you're speaking.
Yes.
So there are differences which are not universally favouring one or the other route, but depending upon the case, you might decide to go one way or another.
Well, it would be extremely odd as a lawyer, not to advise your client
Yeah.
to take the route that requires you to prove the least in order to make good your cause of action. So that's...
Well, unless you could prove more and get more.
Well, the difference, a basic award is a very small sum of money in the run of things. In Osipov, the claim ultimately was worth something like £2 million. The basic award is worth something like £2,000 or £5,000, something that's minuscule in comparison. Of course, not all employees are well
Right,
paid.
but I'm looking for things that might tempt me down what you say is a forbidden path. To go under Part 5 once I've been dismissed, simply
Yes.
sue the top brass and pin it on the employer.
Yes.
Then the thing you've most mentioned is that I might find it easier to get home.
Yes, unquestionably easier for you to get home on a cause of action, but that's a cause of action which we say is precluded by Section 47B2. We say that you can have your Section 103A claim under Part 10 against the employer, and you can even have your Section 47B1A claim against the managing director or the person who made the decision to dismiss you or rejected your appeal or whatever it may be. But what you can't have is to get around Section 47B2 through the back door when you don't, rather than going through the front door of Section 103A. That's what is required by this Act.
Thank you.
So when any company or other employing organisation dismisses an employee, it's necessarily going to act through human agents who will either be workers within the extended definition of 43K. And if every dismissal by an employer could be recharacterised as a detriment inflicted by a co-worker for which the employer is liable, then Section 47B2 would be meaningless. And in this case, the entire claim is one of dismissal, unlike Osipov or others where there were distinct other detriments that were relied upon. So in this case, the appellants are seeking to argue that even the owner carrying out the dismissal falls within a permissible claim, which we say it cannot be. That would be more than simply to narrow the scope of Section 47B2. It would be to effectively void it in its entirety, swallowing up its effect. We say Parliament cannot possibly have intended this. Had it intended that that would have been the effect, then it would have removed it in 2013 or amended it or changed it from this section doesn't apply to particular subsections don't apply. And so we say that this claim was indistinguishable from a Section 103A claim. We say that there's no basis for concluding that Section 47B2 remained on the books by virtue of some oversight or error, not least because it was specifically replicated in 2021 for Section 44.4 on health and safety cases. And it's important to go back to the presumed intention of Parliament when enacting the 2013 changes, which were, of course, to remedy the situation in Fessett. And the situation in Fessett was that a claimant could be subjected to a detriment by a co-worker, effectively being harassed by that co-worker. And those acts, because they could not be described as acts of the employer, meant that there was no legal liability on the co-worker or legal liability on the employer via vicarious liability. That is, we say, a world apart from a situation involving dismissal, because that must necessarily be an act of the employer. And I've taken to the relevant part of Bourne's judgment in that respect. We say that it's rational and certainly not irrational to delineate whistleblowing rights in this way through the distinction between Part 5 and Part 10, and that there are obvious disadvantages to having two separate dismissal rights against an employer based on whistleblowing. To do otherwise, to do as the appellants would invite you to do, would mean that potentially, in respect of the same act and the same prescribed ground of whistleblowing, the employer may simultaneously be found to have lawfully dismissed the claimant under Section 103A, but to have unlawfully dismissed the claimant for whistleblowing under section 47B in respect of the same dismissal. So if it's managing director of company dismisses me and I say it's because of whistleblowing, it would be possible for the tribunal to conclude that the reason or principal reason was not whistleblowing but something else, for example, misconduct, and yet at the same time, via the route that the appellant urges on you to say, well, you know, Mr. X, the managing director, was individually liable for that, and the employer should be vicariously liable for that, and to find that act of dismissal was one for which...
Well, why would that be odd? I mean, in a civil context, you can have somebody suing a school and suing a deputy head teacher or something like this, and their claim against the school fails, but their claim against the head teacher succeeds.
This is in respect of two claims against the school in your example. So what the appellants would be saying is they could bring a claim against the school as section 103A. They can bring a claim against the school...
I'm not talking in the employment context, I'm talking about in the civil context.
Yes.
I'm saying a situation in which after investigation an employer is found not to have done anything wrong, but an employee is found to have...
Yes, I think maybe I haven't made myself clear. I'm not looking at the situation where an individual might be liable, but the school might not be liable. I'm looking at, on the appellant's case, it would be possible to bring three claims. One against the employer under section 103A, another claim against the managing director, let's say, under 47B1A, and a third claim against the employer under section 47B1B, relying on the vicarious liability of the employer for the acts of the managing director. And it would be possible in that scenario for there to be two different outcomes against the same employer in respect of the same dismissal, which is impugned on the same prescribed grounds, i.e. the dismissal having been made for a protected disclosure.
And that's because the causation test for protected disclosure detriment is on the ground of that, and the test for unfair dismissal, automatically unfair dismissal, is reasonable principal reason.
Yes, precisely, Your Ladyship. Yeah. And so that again goes against the grain in terms of the constitutional point on statutory interpretation. How is a member of the public, how is a citizen to understand how they are to conduct themselves, what are they to make of potential judgments where, in respect of whistleblowing in two different cases involving the same prescribed ground, same dismissal, there could be two completely different outcomes. We say that must be wrong.
Right now, can I just take stock of where we've got to?
Yes.
I have an eye to the time.
Yes, indeed. I think I'm almost there, my lord. We say that effectively the points that have been put forward are by the appellants and indeed by Protect may well have advantages for whistleblowers, but those are matters that go way beyond the remit of this court in undertaking an exercise of statutory construction. And there are a number of absurdities that could follow in the event that their interpretation was adopted in disproportionate counter mischiefs, not least that it may mean that individuals who are employed by corporate entities or entities other than sole traders may have better rights than those who are employed by sole traders. So, for example, on the appellant's case, if I were to employ a personal carer, there would be no scope for bringing a claim under section 47B1A if I'm the employer. I'm a private individual and I have a personal carer because I've got a disability. There would be no scope for me to bring a section 47B1A claim and no scope for vicarious liability in respect of that detriment of dismissal. But apparently much enhanced rights in respect of individuals who are employed by corporate entities, where one could point to human agents acting on behalf of the employer or employees of that employer. So we say that is just one example of one of the illogicalities that's put forward by the appellants. My lady, my last point is simply to come back to your point on where it is that Lord Justice Underhill deals with 47B2. That's in paragraph 71 through to 75 of the judgment, and that's where he identifies that he rejects a literal construction of section 47B2.
That's helpful. Thank you very much.
Thank you. Unless thank you. Unless I can assist further, those are my submissions.
Can I, as you're here under your own steam, thank you, and Ms van der Berg and Mr Coincide for doing so. It's been very helpful to the court and to the other parties that all this should be fully argued out.
Thank you.
Thank you. Yes. Right, Mr Midwell-Leonard, we can sit until past, and I think, unless you prefer to start in the morning, would it be useful to spend some of the time now?
Yes, my lord. It might be helpful if I set out some of the interpretations I give of the judgment of the Employment Tribunal, just to leave it overnight, so I could do a few minutes and
yes,
then...
would you like to do a section, as it were, and
yes,
because we're having to now adjust our thinking to the second appeal, and it would be helpful, I think, if we could, if you could introduce it and get us moving in that direction before we break. But we don't have to sit to exactly 4:30. If you feel you've reached a convenient moment, please tell us.
yes, my lord. I'm very grateful. My lord, the starting position for our side of the appeal, if I can put it like that, is I act for Barton Turns Developments Ltd. I appeared in the Employment Appeals Tribunal. My learned friend, Mr. Geoffrey Casey, appeared for the claimant, Miss Treadwell, and he now appears here with Mr. Canning. We approach the case from a slightly different perspective. We reframe this appeal as being about a pair of cases in which amendment applications have been determined as more or less mirror images of one another in respect of the dismissal as a detriment claim. In our side of the appeal, there are some other amendment applications as well for other detriments, which I shall address separately. But the core legal question, which is how does section 47B2 apply, we say is material to the question addressed by the employment tribunals, which is how does it affect the fundamental exercise of any amendment application to balance the injustice or hardship in allowing or refusing the amendment. So what I mean by that, my lord, is that if section 47B2 permits a claimant both to pursue and to win in concurrent claims under section 47B and section 103A, that is a different position than if it is a purely alternative claim, which could not succeed if the section 103A claim succeeded. So we say this court has to determine how section 47B2 applies, but applying that to the instant case, ultimately this case is about amendment applications. And we say that the Employment Tribunal decision in our case to refuse the amendment in respect of dismissal was correct. And we give various reasons for that. And we also address the other amendments as well. To address you, I'm going to
the reasoning for or against granting the amendment application was really based upon a pure legal analysis, wasn't it? I mean, it's not simply a case management decision in which we're being urged that this was the right or the wrong thing to do. It all comes back in the end to 47B2.
Yes, my lord, it does in respect to the detriment as a dismissal. We also rely on subsidiary arguments because we as I say, we are the mirror of Wicked Vision. So the appeal in respect of dismissal was not allowed at first instance, but was allowed before the Employment Appeals Tribunal. We say now that applying ordinary case management considerations in any event, both of the dismissal allegations are significantly out of time in both cases by the time they're raised at those preliminary hearings, and we say that even then, just applying those principles, those amendments should not have been allowed. But that fundamental question of balancing the relative hardship, well, what claim is not being allowed is a relevant question. How can a tribunal judge decide exactly how much hardship one party is suffering if it doesn't know what claim it's potentially depriving them of, my lord?
Let's take this slowly for a moment, because we're moving quite a lot of intellectual furniture around while we move from one appeal to the other.
Yes, my lord.
Can we just remind ourselves what your grounds of appeal are? To do that, I'm going to need to pull up the correct bundle.
Yes, my lord. There are 3 grounds of appeal.
Yes, so I had it, is this at 16, page 6? Oh, it's numbered differently, 14 in the core bundle.
Yes, my lord. Just bear with me a moment. So those are at page 25, my lord, in the core bundle.
Right.
So,
Yes, well, that's where you put them in your skeleton argument. Right, so can we just remind ourselves of what those are? Right, so 1 and 2 are pure points of law.
yes, my lord.
And how is 3 any different?
So the other amendments were treated by the first instance employment judge and by the Employment Appeals Tribunal as mere relabelling exercises. But we say that that is not correct and that they should not have been allowed. We also question the reasoning of the Employment Tribunal judge. We say that that has not, the law has not been applied by the employment judge.
Right, so you're going to take us to, under ground 3, some other considerations that we've not been considering in the Rice appeal.
Yes, yes, my lord. So my proposal, in terms of headings, was the first heading is that anatomical comparison of the appellate cases, and to go through the detailed facts of Barton Turns Developments and Treadwell. Then to move on to the Treadwell amendment applications, which, because of the Employment Appeals Tribunal's decision, does overlap with the dismissal claim as well. We have some very brief submissions about the correct approach to a ratio, and then addressing ratio of Osipov and related authorities. And the last heading is the practical effects. But this afternoon, I will begin that anatomical comparison. One of the central considerations is the timing of when Section 47B2 is applied. So when does a detriment amount to a dismissal? When should the law be applied in that respect? In the instant case, both the cases before the court today concern decisions made at preliminary hearings, where amendments were made to pursue those claims. Both individuals had in-time claims under Part 10 of the Employment Rights Act 1996 and wanted to add claims under Section 47B. That is obviously a different case to Timmis and Osipov, which concerned the liability of individuals where judgment had been given. The compensatory regime under Part 10 was not available because of insolvency.
We're talking about both. You're talking about both claimants' situations.
So we say the position of both claimants in this case concerns a preliminary hearing stage, applying for an amendment. So we don't know if the claims will even succeed at that stage.
But they're applying to amend, but the arguments that we have to consider would apply if they'd started off with these claims, would they not?
It seems to me that is a...
It happens that these matters are seeing a certain amount of support. It happens by coincidence, whatever, that we're considering amendment applications, but it could have been original applications which were then attacked for legal error.
Yep.
So that's anyhow. You started with both claimants wanting to add a Part 5 claim on the back of an in-time Part 10 claim.
Yep.
And you then went on to something that I interrupted you on, which was a reference to Osipov by contrast, or was it a further common feature of these claims?
No, my lord. It was to contrast the position in Osipov, and we say that the explanatory principle is about the availability of the compensatory regimes provided by Part 5 and Part 10. So, in a sense, we adopt the position of my learned friend, Ms. Matrahi KC. I mean, if her interpretation is correct, then obviously we succeed in the appeal. However, in the alternative, and really tracing a line through Melia and Manukanse, through Osipov, we say it's about the availability of the compensatory regimes. And you're not going to know that until liability has been determined. One of the things I have done in my skeleton argument, by lords, I've set out possible interpretations of the Employment Tribunal's judgment. I appreciate it's quite late in the day and we don't have an awful lot of time, but I think it would be useful to set those out. So if I'd be grateful if you turn to page 27 in the core bundle. There is a way of reading section 47b2 that it simply precludes any claim of a detriment as a dismissal as defined in Part 10. The definition of a dismissal, as my lord quite rightly referred to earlier, is in section 95. And that interpretation, which as I say we don't pursue before this court, but that interpretation is that any employee who is dismissed or constructively dismissed cannot pursue a detriment claim under section 47b whatsoever. That is an extreme position, simply applying the wording of section 95. And there's one way of reading the Employment Tribunal judges, Judge Ahmed's decision as effectively reflecting that understanding. The second approach is slightly different. This that section 47b2 prevents a claim from succeeding in a detriment claim where the dismissal has been pleaded and they have won the claim under Part 10. So all they need is to establish liability under Part 10. And in that sense, then it is a dismissal within the meaning of Part 10. And one of the differences that I would like to emphasise in terms of the statutory scheme is we say it is any dismissal under Part 10. And often the comparison is made between section 47b and 103a, and that is understandable because they clearly address whistleblowing. There's a passage I'll pick up later in Media Manukanse which describes how they are both introduced by the PEDA Act 1998, and that in some sense they are complementary of one another. However, we say that because of the way the statute is written, the bifurcation is between section 47b and any remedy under Part 10, any Part 10 claim. I'm not able to pursue either of those first two interpretations, my lord, because they contradict Timmis and Osipov. Because in Timmis and Osipov, Mr. Osipov is an employee and he is dismissed. So that's the first one gone. And we say, as I shall address you more on tomorrow, in more detail tomorrow, we say that is what Lord Justice Underhill is addressing. That is the argument he is dealing with. He is addressing the principle that just because the detriment is a dismissal, it doesn't mean there are no circumstances when it can succeed under Section 47B. The second interpretation, whether there's been a successful Part 10 claim, well, that is also the case in Timothy Osipov. Mr. Osipov wins his Section 103A claim. And so we say that cannot be consistent with Timothy Osipov, and I can't advance that argument either. What we say is the third of these, that Section 47B2 prevents a claim from succeeding in a detriment claim under Section 47B in respect of dismissal, where, if it was pleaded, it could lead to an award of compensation under Part 10. And I've given it some nomenclature, my Lord, which may be helpful, it may be rather clunky, but it's the potential Part 10 approach. And part of what that is about is reading Timmis and Osipov in the round, although it doesn't exactly address this point, that isn't the focus of the judgment, but it has in mind that it's about the substance of the claim. And so we say it's not open to an employee to choose. They cannot simply choose to bring a claim under Part 5. If their dismissal could be compensated under Part 10, then Section 47B2 would apply. And we say that is something that has to be determined at a liability hearing. Now, I've given some comparisons, my Lord. They're of limited value, and I accept that. They are anti-overlap provisions in the Equality Act. Where they are relevant is that one of the things that is going to be said in this case is that what this interpretation, which I say is consistent with all of the authorities, this interpretation is all the authorities, apart from those in the Employment Appeals Tribunal, that this interpretation is in some ways impractical, and that the Employment Tribunal couldn't do this. We say that that is wrong, my Lord. We say that the comparisons we make are between Section 18 of the Equality Act in respect of pregnancy and maternity discrimination, where the existence of certain factors simply prevents a Section 13 claim. It doesn't matter whether the Section 13 claim has been pleaded. That is a route that Parliament has chosen to take, and we say that that is a coherent approach. Similarly, we make comparison with Section 212 of the Equality Act. The position is a little different there. I suggest that that approach depends on whether a Section 13 claim and a Section 26 claim of harassment have both been pleaded, and then a tribunal has to go through a process which I'll refer to more tomorrow, a process of deciding whether the harassment claim has won. If so, then the Section 13 claim cannot succeed. So
this is your paragraph 17 of your skeleton.
Yes, my Lord. And the reason I raise those points now is that one of the things that certainly I protect and I agree about is that practical guidance of how an employment tribunal is to approach these cases would be very welcome. One of the other things to address before I address the facts in more detail is that the remedies under Part 10 we say are very significant. I've termed them the unique quartet of remedies available to an employee. So they include a basic award, which, although it is comparatively modest, it reflects length of service. A declaration that the dismissal is unfair.
Paragraph 23, just so we're
yes,
keeping our note up.
Yes, my Lord. And part of this is that in respect of Section 18(7) of the Equality Act, why would Parliament prefer a claimant to succeed under Section 18 for pregnancy and maternity discrimination and not Section 13 of the Equality Act. The remedies are identical, and it may well be. It's just because the label of the kind of discrimination is in and of itself important. We say the fact that there's a declaration that the dismissal is unfair is itself an important factor that Parliament has decided on. The other two unique benefits are rather more powerful. One of those is potential order for interim relief. I can turn these up now, although I appreciate it is quite late in the day, but it's the page reference is Supplementary Authorities Bundle, page 114, where Section 128 of the Employment Rights Act 1996 is set out.
Sorry, page again.
Sorry, my lord. Supplementary Authority Bundle 114. And then the last of those is the potential order for reinstatement or re-engagement. And that's at Supplementary Authorities Bundle, page 103. And Section 113 and 114 of the Employment Rights Act 1996 give to an employee very powerful and unique remedies in this sense that I don't think it's controversial that an employment contract is an unusual contract. It's a personal contract of service, and because of that, a general remedy of specific performance is not available. But if looking at those provisions, there is a high level of interference, in effect, permitted by an employment tribunal in an appropriate case. There are significant safeguards and a significant test to be met. But if we look at page 103, Section 114, subsection 2, on making an order for reinstatement, the tribunal shall specify any amount payable by the employer in respect of any benefit which the claimant might reasonably be expected to have had but for the dismissal, including arrears of pay for the period between the date of termination of employment and the date of reinstatement, any rights and privileges, including seniority and pension rights, which must be restored to the employee, and the date by which the order must be complied with. Goes on, if the complainant would have benefited from an improvement in his or her terms and conditions of employment had he not been dismissed, an order for reinstatement shall require him to be treated as if he benefited from that improvement from the date. And similarly with re-engagement. Subsection 2 of paragraph section 115 on page 104, making an order for re-engagement. The tribunal shall specify the terms which re-engagement take place, including that case.
Do we need the full terms of this? I mean, re-engagement, we can understand.
Yes. Well, I'm grateful. The short point I make is that those are very substantial remedies, and there is plainly a real logic for Parliament to have prioritised those. But putting it this way, there is one way of approaching this appeal where we can suggest that Section 47B2 should be taken as read, and it states very clearly that the section does not apply once that test is met. And I appreciate there's some dispute about the test, but we do encourage an all or nothing approach. Either the whole section applies or it doesn't. And it cannot be right that there can be cherry picking of parts of it. My learned friends for the appellants in Wicked Vision haven't spelled out exactly how one does this. Is it simply a matter of pleading? And for the reasons I shall pick up tomorrow, I say that cannot be right. In the case of Barton Turns, the claimant did not say which section of Section 47B was relied on, either at the time of submitting the claim or at the time of applying for an amendment. And Lord Justice Underhill has commented on more than one occasion that it doesn't really make a difference, and that it, in a sense, it doesn't matter. Both involve a degree of attribution, both involve a degree of vicarious liability. But I shall pick that up in more detail tomorrow. I think the last comment I want to make before I go into the facts, I appreciate it is quite late, my lord. There has been reference to by my learned friend to the restriction on claimants who are employees under section 47B. And that's found in section 49 of the Employment Rights Act 1996. If you could turn to the Supplementary Authorities Bundle, page 81. And it runs on to page 82, and it's subsection 6 of section 49. And it spells out that where the detriment to which a worker is subject is the termination of the worker's contract. The contract's not a contract of employment, but if the worker had been an employee and had been dismissed for the reasons specified in section 103A, the compensation must not exceed the compensation. Now, compensation for loss of earnings under section 47B and 103A is uncapped. The difference is an injury to feelings award. To my knowledge, and obviously my learned friends haven't raised it either, to my knowledge, there is no authority where this express point has been taken. So, for example, it would be open to a respondent in such a case with a worker to say, well, the injury to feelings award must either not be awarded because it wouldn't be available to an employee in this situation, or it must be restricted to the equivalent of, say, a basic award or some equivalent like that. But the point we make is that Parliament clearly had an intention that workers would not be in a better position, and that's reflected by the statute.
Yes.
My lord, I'm aware of the time. I'm happy to pick up.
Yes, well, we'll start tomorrow with the facts.
Yes, my lord.
What rise of able?
10:30.
Oh, yes. Are you going to ground report not the same as the skeleton argument? I should do that.
Yes, I will.